Get ready. 3 seconds. 2 seconds. Start. The appellant was convicted by the learned district and session judge, Kamrup, in sessions case number 15 for the offence punishable under section 304 part 1 of the penal code, 1860, and sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 200 with default stipulation. Full stop. The learned single judge of the Guwahati High Court partially allowed the appeal filed by the appellant and altered the conviction to section 304 part 2 IPC and sentenced the appellant to undergo RI for 5 years. Full stop. The appellant was accused of assaulting the victim, resulting in his death due to head injury. Full stop. Para. Section 313 of the Criminal Procedure Code, 1973, cast a duty on the court to put in an inquiry or trial questions to the accused for the purpose of enabling him to explain any of the circumstances appearing in the evidence against him. Full stop. The examination of an accused under section 313 of the code is not a purposeless exercise. Full stop. Any circumstances in respect of which an accused was not examined under section 342 of the Criminal Procedure Code cannot be used against him. Para. The High Court found that the proper conviction would be under section 304 part 2 IPC. Full stop. However, the circumstances which led to the conviction were not put to the appellant in his statement under section 313 of the Criminal Procedure Code, 1973. Full stop. As a result, the appellant did not have any chance to explain them. Full stop. This goes against the rule of law that any circumstances in respect of which an accused was not examined under section 342 of the Criminal Procedure Code cannot be used against him. Full stop. Therefore, the examination of the accused under section 313 of the code was rendered an empty formality. Full stop. Para. In this appeal, challenge is to the judgment of a learned single judge of the Guwahati High Court, partially allowing the appeal filed by the appellant. The learned district and session judge in sessions case number 15 convicted the appellant for the offence punishable under section 304 part 2 of the penal code, 1860, and sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 200 with default stipulation. Full stop. Para. Background facts in a nutshell are as follows. On 14/9/1986 at about 8 p.m. an FIR was lodged by PW1 before the officer in charge, police station, mentioning therein that at about 9:30 a.m. on that day the accused, assaulted the son of Haider with a piece of wood, as a result of which the victim sustained injuries on his head. Full stop. The injured was moved to Guwahati Medical College Hospital, where he succumbed to the injuries at about 5:30 p.m. Full stop. The police registered a case and, after completion of the investigation, submitted charge sheet under section 302 IPC. Full stop. Para. The accused was examined under section 313 of the Code of Criminal Procedure, 1973, who denied his involvement in the offence. Full stop. as rightly contended by the learned counsel for the appellant, no witness has stated that on the date of occurrence, the accused had caused severe injury to the deceased by assaulting him on the head from behind. Full stop. The circumstances which were relied by the trial court to find the accused guilty were not specifically brought to the notice of the accused. Full stop. Therefore, comma, in essence, comma, his examination under section 313 of the code was rendered as empty formality. Full stop. On that count alone, comma, the impugned judgment of the High Court cannot be sustained and is set aside. Full stop. The conviction recorded stands set aside. Full stop. The bail bond of the appellant who is on bail shall stand discharged. Full stop.